Theft. 1. Constructive possession. A cargader riding on a truck hauling cases of milk belonging to complainant threw out 2 cases as the truck passed a certain street. The crime is consummated theft since the cargader acquired constructive possession over the cases of milk when he threw the same from the truck. Gaining constructive possession is considered as taking, which consummates the crime of theft. 2. Asportation. Taking is deemed complete from the moment the offender gains possession over the thing, even if he has no opportunity to dispose of the same. People v. Bustinera. GR 148233. Jurisprudence is settled that to take under theft the revised penal code does not require asportation or carrying away. Medina v. People 182648. It is not an indispensable requisite of theft that a pickpocket should carry, more or less far away, a wallet taken from its owner. People v. Mercado. This rule is applicable to robbery. Even though the stolen property was immediately recovered from the robbers, the crime of robbery is consummated since they gained possession over the property momentarily. Offenders are liable for consummated robbery by means of violence or intimidation, though they failed to bring out the property from the building. Ability to freely dispose the property is not an element of robbery. People v. Salvilla 86163. In robbery by using force upon a thing where the subject property is inside a receptacle or furniture, the crime is attempted if the property is still inside the receptacle or furniture in the building because the owner still has constructive possession over the property. To consummate the crime, the robber must take the property out from the building. People v. Del Rosario. Same as in theft and robbery by means of violence or intimidation, ability to freely dispose the property is not an element of robbery by using force upon thing. Hence, bringing out the stolen property from the building is not necessary to consummate the crime of robbery by using force upon thing. In robbery by using force upon thing where the subject property is inside a receptacle or furniture, the crime is attempted if the property is still inside the receptacle or furniture because the owner still has constructive possession over the property. To consummate the crime, the robbers must take the property out from the receptacle or furniture. There is no need to take the property out from the compound, but if the intention of the robbers is to break the locked receptacle or furniture outside the building, the crime will be consummated only upon removal of the receptacle or furniture from the building. 3. Capacity to freely dispose the property. In Dino's case, theft was considered as frustrated because of the inability of the accused to freely dispose the bulky goods for failure to bring them out of the compound. However, the Supreme Court in Valenzuela v. People 160188 expressly abandoned the Dino case. In Valenzuela case, if the properties are taken by the accused inside a compound, theft is consummated, even if the accused failed to bring out the stolen goods from the compound, which makes him unable to freely dispose it. Unlawful taking is deemed complete from the moment the offender gains possession of the thing, even if he has no opportunity to dispose of the same. Inability to dispose the stolen property is not an element of theft. Unlawful taking is the element which produces the felony in its consummated stage. Without unlawful taking, the offense could only be attempted theft, if at all. Thus, theft cannot have a restated stage. 2013. The crime of theft is consummated even though the offender, after unlawfully taking the property, failed to bring it out from a department store or dwelling or the parking area of SM. People v. Valenzuela. If the accused is charged with frustrated theft, he could not be convicted of the crime charged because theft has no frustrated stage. Neither could he be convicted of consummated theft since it was not alleged in the information, but he could be convicted of attempted theft because the crime is necessarily included in the charge of frustrated theft. Canceran versus People, 206-442. The Valenzuela principle can be applied in robbery by means of violence or intimidation, since taking, which is the subject of interpretation in that case, is the criminal act in both theft and robbery. Hence, taking or gaining possession over the property with intent to gain by means of violence or intimidation consummates the crime of robbery. People versus Salvilla, 86163. Theft and Staffa. In United States versus Adiao, 13785, a customs inspector took a leather belt from the baggage of a passenger. He kept it in his office desk, where the other employees found it afterwards. The crime committed is consummated theft. Taking or gaining possession over the property with intent to appropriate consummates the crime of theft. In U.S. versus Dominguez, 17021, a salesman, with intent to misappropriate the proceeds of sale, failed to surrender the money to the cashier of the complainant. He delivered them to the cashier only after the deceit had been discovered. The crime committed is frustrated estafa through misappropriation. Unlike in theft, gaining possession of the property would not consummate the crime, since damage is an important element of estafa. The crime is frustrated inasmuch as he performed all the acts of execution which should produce the crime as a consequence, but which, by reason of causes independent of his will, did not produce it, no appreciable damage having been caused to the offended party due to the timely discovery of the acts prosecuted. In the Dominguez case, the accused was just an employee of the complainant, and yet he was convicted of frustrated estafa through misappropriation. However, it is now a settled rule that possession of employee over the property of the employer is physical, and thus misappropriation thereof is considered as taking, which constitute the crime of consummated theft. People versus Locson. Direct bribery and corruption of public officer. In crimes like betting in sports and corruption of public officers, which require the intervention of two persons to commit them, the same are consummated by agreement. The offer made by one of the parties to the other constitutes attempted felony, if the offer is rejected. Bribery and corruption of public official are two different and distinct felonies. Bribery is the crime committed by a public officer who accepts the bribe. On the other hand, the person who gives the bribe is liable for corruption of public official. 1. Corruption of public officer. Corruption of public official is either attempted or consummated. If the public officer accepted the bribe, the person he gives or offers the bribe is liable for consummated corruption of public official. If the public officer rejects or returns the bribe, the person who offers the bribe is liable for attempted corruption of public official. Poser versus Court of Appeals. Corruption of public officer is a crime which is consummated upon the performance of acts of execution by two persons, to wit, offer or bribe by the offender and accepted by the public official. Such crime has no frustrated stage because if the public officer accepted the bribe, the crime of corruption of public officer is consummated. But if the public officer rejected the bribe, the crime is attempted. People versus Nungpek. L1895. Direct bribery is always consummated. Agreement. The criminal act in direct bribery is agreeing to perform an act constituting a crime in connection with the performance of these official duties in consideration of any offer, promise, gift, or present. Whether the bribe money was offered by the private individual or solicited by the public officer, if there is an agreement, the public officer is liable for consummated direct bribery, while the private individual is liable for corruption of public officer. People versus Cisco. In this case, the public officer agreed to perform the act. Rejected offer of public individual. If bribe money was offered by the private individual, but the public officer rejected the offer, the former is liable for attempted corruption of public officer. People versus Nungpek. Posa versus Court of Appeals. On the other hand, the public officer is not liable. Even if the public officer rejected the offer because of suspicion that he is being entrapped, the public officer is still not liable for direct bribery. Public officer who immediately returns the bribe money handed over to him is not liable for bribery since he did not accept the bribe money. Rejected solicitation of public officer. If the public officer solicited money from the private individual in consideration of doing an act constituting a crime in connection with the performance of his duty, but the latter refused to give money, the former is not liable for consummated direct bribery. Soliciting cannot be considered as within the context of agreeing, which is the criminal act punished as direct bribery. Neither is he liable for attempted direct bribery. This crime has no attempted stage, since there is no such thing as attempt to agree by soliciting money. A policeman told the over-speeding driver whom he arrested that he will release him without any case being filed if he give 10 pesos. The driver refused and instead filed a case of attempted bribery against the policeman. The driver did not file the proper case. There is no attempted bribery because of the nature of the crime. Soliciting of bribe is not punished under Article 210 of the Revised Penal Code, which refers to an agreement to perform or not to perform an act in consideration of a gift or promise. Paragraph 3 of said article punishes the act of receiving a gift or accepting a promise if given or promised to make the public officer refrain from doing something which was his official duty to do. The crime committed is violation of Section 7 of RA 6713, Code of Conduct and Ethical Standard of Public Officer. Section 7, letter D. Solicitation or acceptance of gift. Public officials and employees shall not solicit or accept directly or indirectly any gift, gratuity, favor, entertainment, loan, or anything of monetary value from any person in the course of their official duties or in connection with any operation being regulated by or any transaction which may be affected by the functions of their office. Coercion. A boarded plane at the airport bound for Davao City. While plane was still on the tarmac, its doors still open and waiting for the last passenger to board, A ordered the pilot P at gunpoint to take the plane to Singapore. When P refused, A shot him to death. The crime committed is frustrated coercion and murder. 3 accused forcibly took their victim from his car, but the latter succeeded in freeing himself from their grip. There being neither actual detention or confinement nor clear intent to detain, the accused should be held liable for consummated grave coercion and not attempted kidnapping or illegal detention. 2011. Formal crime. Formal crimes such as slander, perjury, false testimony, and illegal possession of pick clocks are those which are consummated in one instant or by performance of a single act of execution. They have no attempted or frustrated stage. Physical injuries. According to Justice Regalado, the crime of physical injuries is a formal crime since a single act consummates it as matter of law. Hence, it has no attempted or frustrated stage. 2017 bar. Accused deliberately throws acid to the face of another with intent to blind him. In other words, his intention is to commit serious physical injuries. However, injuries caused in the eyes of victim were completely healed in 25 days. Accused is not liable for consummated serious physical injuries because he did not cause blindness to the victim. Neither is he liable for frustrated serious physical injuries since it is a formal crime. The crime committed is less serious physical injuries since the same required medical attendance for 10 days or more. Acts of lasciviousness. Accused hugged the victim and tried to touch her breast. In the process, her dress from the collar to the waistline on the front part was torn. However, she was able to get free and moved away. The accused desisted from following her. The crime committed is not frustrated acts of lasciviousness. Acts of lasciviousness are always consummated. People versus Famular Cano. Hugging the victim with lewd design constitutes consummated acts of lasciviousness. Coup d'etat. Coup d'etat is a formal crime. It has no frustrated or attempted stage. Once the military, police, or public officer made a swift attack against facilities needed for the exercise and continued possession of power for the purpose of seizing or diminishing state power, the crime is consummated. Actual seizure or diminution of state power is not necessary for the consummation of the crime, but prior to a swift attack, the plotters of coup d'etat can be held liable for conspiracy to commit coup d'etat. No stages. Whether attempted or frustrated, the offender had performed acts to execute his criminal design. The only difference is that in frustrated felony, the offender already performed all acts of execution, while in attempted, he did not perform all acts necessary to execute his criminal design. Performance of acts to execute criminal design is not compatible with the concept of culpa. Hence, a person cannot be convicted of attempted or frustrated homicide through imprudence. Conspiracy and proposal. There is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. A conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Article 8 of the Revised Penal Code. As a rule, the principle of conspiracy as a mode of committing a crime or for purposes of applying the collective responsibility rule is only applicable to intentional felony. The concept of conspiracy, the elements of which are agreement and decision to commit a crime, are not consistent with culpable felony. Persons cannot definitely agree and decide to commit a culpable crime. However, there is an exception, that is, the doctrine of conspiracy of silence or inaction. In Jaga v. People 166967, a paymaster obtained cash advances despite the fact that she has previous unliquidated cash advances. The city treasurer certified that the cash advances are necessary and lawful. The city accountant certified that the expenditures are supported by documents and previous cash advances are liquidated and accounted for. The city administrator approved the voucher and countersigned the check. City treasurer, city accountant, and city administrator are liable for violation of Section 3, letter E of RA 3019, committed through gross inexcusable negligence. They are liable because of conspiracy of silence or inaction. Public officers' omissions to question irregularities indicate a common understanding and concurrence of sentiments respecting the commission of the offense. Section 3, letter E of RA 3019. Causing any undue injury to any party, including the government, or giving any private party any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions through manifest partiality, evident bad faith, or gross inexcusable negligence. This provision shall apply to officers and employees of offices or government corporations charged with the grant of license or permits or other concessions. Conspiracy as a crime. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specifically provides a penalty therefor. Article 8 of the Revised Penal Code. In the following cases, proposal or conspiracy is punishable. Conspiracy or proposal to commit treason. Article 115. Conspiracy or proposal to commit rebellion or coup d'etat. Article 136. Conspiracy to commit sedition. Article 141. Conspiracy to commit arson. Section 7 of PD number 1613. Conspiracy to commit crime involving trafficking of dangerous drugs. Section 26 of RA 9165. Conspiracy to commit terrorism. Section 4 of RA 9372. Conspiracy to commit child pornography. Section 4 of RA 9775. And conspiracy to commit money laundering. Section 4 of RA 9160. In the following cases, proposal or conspiracy is not punishable: proposal to commit sedition, 2013 bar; proposal to commit espionage, 2011 bar; proposal to commit highway robbery, 2011; conspiracy to commit direct or indirect assault, 2011; conspiracy to commit trafficking in person; and conspiracy to assassinate the president. EO number 183 has repealed PD number 1110-1, which punished an attempt or conspiracy against the life of the president on June 5, 1987. Conspiracy as a mode of committing a crime. Conspiracy does not constitute a crime if the law has not specifically provided a penalty therefor. However, even though conspiracy is not a crime, but if the conspirators committed the crime agreed upon, conspiracy shall be considered as a means of matter or manner of incurring criminal liability. On the other hand, even though conspiracy is a crime, but the conspirators committed the crime agreed upon, conspirators shall be liable for the crime committed and not for conspiracy to commit it. Conspiracy will be considered not as a crime, but as a mode of committing a crime. In conspiracy as a crime, conspirators are criminally liable even though they have not yet perpetrated the crime they agreed to commit. In conspiracy as a mode of committing a crime, the liability of the conspirators for perpetrating the crime they agreed to commit is collective. In conspiracy as a crime, the conspirators will be punished for agreeing and deciding to commit the crime. In conspiracy as a mode of committing a crime, the collective responsibility rule applies if the conspirators perform an act in furtherance of conspiracy. Collective responsibility. The legal effect, once an express or implied conspiracy is proved, is that all of the conspirators are liable as co-principals, regardless of the extent and character of their respective active participation in the commission of the crime that they agreed to commit. They are also liable for other crimes perpetrated in furtherance of the conspiracy. In contemplation of law, the act of one is the act of all. People versus Peralta. Accused are liable for 2 counts of rape on account of a clear conspiracy between them, shown by their obvious concerted efforts to perpetrate, one after the other, the rapes. Each of them is responsible, not only for the rape committed personally by him, but also for the rape committed by the other as well. People versus Lascano. Act in furtherance of conspiracy. To make a conspirator collectively responsible, it must also be established that he performed an act in furtherance of conspiracy. A conspirator who did not perform an act in furtherance of conspiracy to kidnap the victim for ransom is not liable for conspiracy to commit kidnapping for ransom, since there is no law prescribing a penalty for it. Neither is he liable for kidnapping on the basis of collective responsibility rule, because he did not perform an act in furtherance of conspiracy. People versus Beroya, Sub Beroya. If a conspirator failed to perform an act in furtherance of conspiracy because he was apprehended prior to the killing of the victim by his co-conspirator, the former is not liable for the killing since he did not perform an act in furtherance of conspiracy. Mastermind. To be held liable as conspirator based on the collective responsibility rule, it must also be shown that the accused performed an overt act in furtherance of conspiracy, except in the case of the mastermind of a crime. People versus Vera. One who plans the commission of a crime is liable as conspirator and principal by inducement. People versus Comiling. Evidence proved that he was the mastermind of the criminal act or the principal by inducement, notwithstanding the fact that one was not at the crime scene. What is important is that inducement was the determining cause of the commission of the crime. The command or advice made by principal by inducement was of such nature that without it, the crime would not have materialized. People versus Janjalani, 188314. A commander of a vigilante group came to Ricky and showed him a list of 5 policemen to be liquidated by them for graft and corruption. He was further asked if any of them is innocent. Ricky pointed to 2 of the policemen as honest. Later, the vigilante group liquidated the 3 other policemen in the list. The commander of the vigilante group reported the liquidation to Ricky. Circumstances show that Ricky is the mastermind in the killing of policemen. The executioners before the killing consulted him. They did not kill those pointed by him as innocent, and they reported to him the completion of the task. Hence, Ricky is liable as principal by inducement even though he did not perform an act in furtherance of conspiracy. Detaching from conspiracy, to exempt himself from criminal liability, a conspirator must have performed an overt act to dissociate or detach himself from the conspiracy to commit the felony and prevent the commission thereof. Quintus versus People. Before the commission of the crime, if a conspirator dissuaded his co-conspirator from committing the crime agreed upon, People versus Nunez, or made an effort to prevent the commission of the crime, People versus Anticamaray, he is exempt from criminal liability because he detached himself from the conspiracy. A induced B to kill the victim for a valuable consideration, but A tried to stop the killing by calling the police authorities before the actual execution of the crime. A is not liable because he detached himself from the conspiracy to commit murder. Before the actual commission of robbery with homicide by the chief actor in the dwelling of the victim, his co-conspirator fled for being scared when police car with sirens blaring passed by. The latter is not liable for robbery with homicide committed by the former. By fleeing, his co-conspirator detached or dissociated himself from conspiracy. Moreover, he did not perform any act in furtherance of conspiracy. However, he is liable for trespass to dwelling, 2003. If a co-conspirator who is supposed to act as a guard outside a house left the scene without knowledge of the other co-conspirator, before the killer could enter the house to execute their plan to kill the victim, he is not liable for the injuries suffered by the victim. By leaving the scene of the crime, he detached or dissociated himself from conspiracy. Moreover, he did not perform any act in furtherance of conspiracy. The commission of the crime is in progress. If a conspirator left the scene of the crime while its commission is in progress and reported the incident to the police authorities, he is not criminally liable because he detached himself from the conspiracy. People versus Nunez. But a conspirator left the scene of the crime while commission of robbery with homicide is in progress without reporting the incident to the police authorities. He is not exempt from criminal liability. Conspiracy has already materialized, hence there is nothing to repudiate. People versus De Los Reyes. After the commission of the crime, if the accused reported the shooting incident after it had already taken place, he is criminally liable. In legal contemplation, there was no longer a conspiracy to be repudiated since it had already materialized. People versus Bakbak. Imputability doctrine. Under the doctrine of imputability, the act of an offender is imputable to his co-conspirator, although they are not similarly situated in relation to the object of the crime. Malversation. Only an accountable officer can commit malversation, but if there is conspiracy, the act of an accountable officer in committing malversation is imputable to non-accountable officers or private individual, although the latter were not similarly situated with the former in relation to the object of the crime committed. U.S. versus Ponte. Rape through sexual intercourse. Only a man can commit rape through sexual intercourse against a woman, but if there is conspiracy, the act of a man in committing rape is imputable to a woman, although the latter was not similarly situated with the former in relation to the object of the crime committed. People versus De La Torre. Violation of BP 22. BP 22 does not expressly prescribe the supplementary application of the provisions of the revised penal code, including the rule on conspiracy. Hence, such rule may be applied in a supplement manner. Ladonga versus People. Thus, if there is conspiracy, the act of issuing bouncing check by the drawer is imputable to the non-issuer, although the latter was not similarly situated with the former in relation to the object of the crime committed. Violence against women. The principle of conspiracy may be applied to RA 9262. Thus, the act of violence of a man having marital relationship with a woman is imputable to a person, mother-in-law, of the victim, who has no marital, sexual, or dating relationship with the victim, although both accused were not similarly situated in relation to the object of the crime committed. Go Tan versus Go. Corruption. Only a public officer can be held criminally liable for violation of R8 3019. However, if there is conspiracy, the act of the public officer in violating R8 3019 is imputable to the private individual, although they are not similarly situated in relation to the object of the crime. Moreover, Section 9 provides penalty for public officer or public person for crime under Section 3. Hence, a private individual can be prosecuted by violation of RA 3019 Henry Go versus the 5th Division Sandigan Bayan. Even though the public officer died, the private individual, his alleged co-conspirator, can still be prosecuted for violation of RA 3019. Death extinguishes the criminal liability but not the crime. Hence, if there is proof of the crime and conspiracy between the private individual and public officer who subsequently died, the former can still be convicted of violation of RA 3019, People versus Henrigo. However, if the public officer is acquitted, the private individual, his alleged co-conspirator, must also be acquitted, Marcos versus Sandigan Bayan. Mayor, treasurer, and planning coordinator approved the overpayments in favor of the private individual for the construction of public market. The public officer caused undue injury to the government through manifest partiality and evident bad faith in violation of Section 3, letter E of RA 3019. The private individual who was overpaid is also liable on the basis of conspiracy. Exceptions. Parricide. Even though there is conspiracy, the act of the wife in committing parricide is not imputable to a stranger. For example, a wife with the help of another killed her husband by means of poison. Since relationship is personal to the wife, it can only be appreciated against her in accordance with Article 62 of Revised Penal Code. Hence, the wife is liable for parricide, qualified by the circumstance of relationship and aggravated by the circumstance of by means of poison, while the stranger is liable for murder, qualified the circumstance of by means of poison. People versus Buksit. Qualified theft. Even though there is conspiracy, the act of the employee in committing theft, qualified by the circumstance of abuse of confidence, is not imputable to a non-employee. The servant and neighbor of complainant conspired and committed the crime of theft. The qualifying aggravating circumstance of abuse of confidence can only be appreciated against the servant, to whom the complainant reposed confidence, but not to his neighbor. The circumstance of abuse of confidence is personal to the servant. The crime committed by the servant is qualified theft, while that of the neighbor is simple theft. People versus Puno. Commission of other crime. Accused may or may not be held liable for crime not agreed upon committed by his co-conspirator. Killing of a third person. A conspirator is liable for a crime which they agreed to commit, and other crimes which could be foreseen and are the natural and logical consequences of the conspiracy. Conspirators agreed to kill the husband, but not the wife, in their house. They could have foreseen the violent resistance from the wife since they committed the crime in their house. Hence, the killing of the wife by one conspirator because of her resistance would make the other conspirators liable for her death, although the conspiracy merely pertained to the killing of the husband. The killing of the wife was the natural and logical consequence of conspiracy to kill the husband. People versus Ventura. But if the killing of a third person is unexpected or unforeseeable, the conspirators who had no foreknowledge of such killing are only liable for the crime they agreed to commit and not for the unforeseeable killing of the third person by their co-conspirators. People versus Caballero. If by reason of conspiracy, conspirators beat their employer at the first floor of the building, but one of the conspirators chanced upon a maid at the second floor shouting for help and killed her, The other conspirators who did not foresee the killing of the maid are only liable for the killing of the employer. They are not liable for the killing of the maid, which is substantially or radically different from the crime they intended to commit. The killing of the maid is not the natural and logical consequence of the conspiracy to beat the employer. Conspirator killed a visitor of the target victim without knowledge of his co-conspirators. The killing of such visitor is neither foreseeable nor the natural and logical consequence of the conspiracy to kill the target victim. Hence, conspirators who had not participated in the killing of the visitor are not criminally liable. Committing homicide or rape in the course of robbery by band. Any member of a band who is present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 296 of the Revised Penal Code. The word assaults in Article 296 includes sexual assault constituting rape. People versus Hamiana. In such case, the members of the band are liable for robbery with homicide or rape with the ordinary aggravating circumstance of band. However, a member of the band is not liable for robbery with homicide or rape if he is not present when the victim was killed or raped. People versus Canturia. Committing homicide or rape in the course of robbery. Case law establishes that whenever homicide has been committed by reason of or on the occasion of the robbery, all those who took part as principals in the robbery will also be held guilty as principals of robbery with homicide, although they did not take part in the homicide, unless it appears that they sought to prevent the killing. People versus De La Cruz. Once conspiracy is established between several accused in the commission of the crime of robbery, they would all be equally liable for the rape committed by any one of them on the occasion of the robbery, unless any one of them proves that he endeavored to prevent the others from committing rape. People versus Suyu. However, if there is no evidence that the accused is aware of the commission of rape, he could not have prevented the rape. Hence, the accused is only liable for robbery and not robbery with rape. People versus Canturia. Canturia principle, where lack of awareness is a defense, is applicable to kidnapping with rape. People versus Anticamaray. Kidnapping with homicide. Robbery with homicide. People versus Corbes. And robbery with arson. Multiple conspiracies. There are two structures of multiple conspiracies, namely wheel or circle conspiracy and chain conspiracy. Under the wheel or circle conspiracy, there is a single person or group, the hub, dealing individually with two or more other persons or groups, the spokes. An illustration of wheel conspiracy wherein there is only one conspiracy involved was the conspiracy alleged in the information for plunder filed against former President Estrada and his co-conspirators. Former President Estrada was the hub, while the spokes were all the other accused individuals. The ring that enclosed the spokes was the common goal in the overall conspiracy, like amassing, accumulation, and acquisition of ill-gotten wealth. Under the chain conspiracy, usually involving the distribution of narcotics or other contraband, in which there is successive communication and cooperation in much the same way as with legitimate business operations between manufacturer and wholesaler, then wholesaler and retailer, and then retailer and consumer, for an engineer versus people. Multiple offenses, recidivism, quasi-recidivism, reiteration, and habitual delinquency are distinguished as follows. Crimes committed. In recidivism, the previous crime and the present crime are embraced in the same title of the Revised Penal Code. In quasi-recidivism, the nature of the previous crime and present crime is not material. In reiteration, the penalty for the previous crime is equal to or greater than that for the present crime, or the penalty for the two previous crimes is lighter than that for the present crime. In habitual delinquency, the previous, subsequent, and present crimes must be serious or serious physical injuries, theft, robbery, estafa, or falsification of document. Period of time. In quasi-recidivism, and reiteration. What is important is the date of commission of the present crime. In quasi-recidivism, the accused committed the present crime before beginning to serve or while serving his sentence for the previous crime. In reiteration, the accused committed the present crime after serving his sentence for previous crimes. In recidivism, what is important is the date of trial of the present crime in relation to date of conviction of his previous crime. In recidivism, the accused was being tried at the present crime when he was convicted of the previous crime by final judgment. In habitual delinquency, what is important is the date of conviction of the subsequent or present crime in relation to the date of his last release or conviction. People versus Morales. In habitual delinquency, the accused was convicted, found guilty of the second crime within 10 years after conviction or release of the first crime. Then he is convicted of the third crime within 10 years after conviction or release of the second crime, and so on and so forth. Number of crimes committed. In recidivism and quasi-recidivism, there must be at least 2 crimes. In reiteration, there must be at least 2 crimes, but if the penalty for the previous crime is lighter than that of the present crime, there must be at least 3 crimes. In habitual delinquency, there must be at least 3 crimes. Effects in relation to the penalty. Recidivism and reiteration are ordinary aggravating circumstances, the presence of any of which will require the application of the penalty for the present crime in its maximum period unless it is offset by a mitigating circumstance. Quasi-recidivism is a special aggravating circumstance, the presence of which will require the application of the penalty for the present crime in its maximum period, regardless of the presence of mitigating circumstance. Habitual delinquency is an extraordinary or special aggravating circumstance, the presence of which will require the imposition of penalty in addition to the principal penalty for the present crime. This is not subject to the offset rule. Recidivism. A recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of this code. Article 14 of the Revised Penal Code. The phrase "at the time of his trial for an offense" employed in defining recidivism includes everything that is done in the course of the trial, from arraignment until after sentence is announced by the judge in open court. People versus Lagarto. However, recidivism can still be appreciated even if before his trial for the present crime he was convicted by final judgment of his previous crime. People versus Bernal. Reiteration. There is reiteration when the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty. Article 14 of the Revised Penal Code. Previously punished. The phrase "previously punished" employed in defining reiteration means that the accused has served out the sentence for his previous crime. Previous crime and present crime. If there is only one prior offense, it must be punishable by a penalty equal or greater than that for the present crime. The penalty for the previous crime of homicide, which has been served out, is reclusion temporal, while that for simple rape is reclusion perpetua. There is no reiteration because the penalty for the previous crime of homicide is lesser than that for simple rape. If there is more than one prior crime, reiteration is present even if previous crimes are punishable by a penalty lesser than that for present crime. Thus there is reiteration even if the penalties for grave slander, qualified trespass to dwelling, or robbery which have been served out are lesser than that for the crime of murder. People versus Molo. In appreciating reiteration, what is controlling is the penalty prescribed by law for the previous and present crimes, if not the penalty actually imposed by the court after trial. Recidivism and reiteration. If the crimes are embraced in the same title, such as homicide and maltreatment, the aggravating circumstance to be appreciated against him is recidivism rather than reiteration. there is no reiteration because that circumstance requires that the previous offense should not be embraced in the same title of the code. In reiteration, the offender commits a crime different from that for which he was previously convicted. People versus Real. Accused was previously convicted of adultery and served the penalty for it and was charged for physical injuries. He was found guilty of homicide. His liability for homicide shall not be aggravated by recidivism or reiteration. He is not a recidivist because homicide and adultery are not embraced in the same title of the revised penal code. Homicide is a crime against person, while adultery is a crime against chastity. Reiteration is not present since the penalty for the previous crime of adultery is lesser than that for homicide. The crime of physical injuries shall not be considered in determining recidivism and reiteration, since he was not yet convicted thereof. Both recidivism and reiteration can be appreciated in murder. There is recidivism since the accused was previously convicted of another murder, frustrated murder, and less serious physical injuries at the time of trial for murder. There is reiteration since he committed murder after serving out the penalties for grave slander, qualified trespass to dwelling, and robbery. Quasi-recidivism. Any person who shall commit a felony after having been convicted by final judgment before beginning to serve such sentence, or while serving the same, shall be considered as a quasi-recidivist. Article 160 of the Revised Penal Code. Quasi-recidivism is an extraordinary aggravating circumstance and cannot be offset by an ordinary mitigating circumstance of voluntary surrender or confession. People versus Macariola. Previous crime and present crime. Quasi-recidivism will be appreciated regardless of whether the previous crime for which an accused is serving sentence at the time of the commission of the crime charged falls under the revised penal code or under special law. People versus Alicia. But the present crime must be a felony punishable under the revised penal code or an offense punishable under special law, which adopts the technical nomenclature of the penalties of the revised penal code. One who committed illegal possession of loose firearm while serving sentence for theft is a quasi-recidivist, although courts of appeals Justice Luis Reyes and Justice Real Galado opined that the second crime must be a felony to appreciate quasi-recidivism because Article 160 speaks of a felony. The Supreme Court in People v. Salazar appreciated quasi-recidivism against the accused who committed a malum prohibitum under RA 6425, the old dangerous drugs law, because this law adopts the technical nomenclature of the penalty under the revised penal code. Since RA 10591 punishes illegal possession of loose firearm, adopts the technical nomenclature of penalties of the revised penal code. Article 160 of the code on quasi-recidivism shall be applied in the imposition of penalty under RA 10591, 2012. Section 98 of RA 9165, which has repealed RA 6425, provides that revised penal code shall not apply to the provisions of this act, except in the case of minor offenders. Thus, the Salazar principle is only applicable if the offender who violated the dangerous drugs law is a minor. After finality of decision, Bernardo, who was enraged by his conviction for robbery by Judge Samsonite despite insufficient evidence, pending his appeal, Bernardo escaped in order to get even with Judge Samsonite. Bernardo killed the judge. Bernardo committed a crime while the judgment of conviction is on appeal. Thus, quasi-recidivism cannot be considered since he did not commit a crime after having been convicted by final judgment. 2017. Before serving sentence, one who committed a crime outside of prison before he begins to serve his sentence for homicide is a quasi-recidivist. If the accused is placed on probation, the conviction shall become final, but the service of sentence shall be suspended. One who committed a crime while on probation is a quasi-recidivist because the crime was committed before serving her sentence for the previous crime for which she is placed under probation. People versus Salazar. The Salazar case applies to one who committed a crime while under parole or conditional pardon. In parole or conditional pardon, the service of unexpired portion of sentence is suspended. A parole or pardonee is a convict by final judgment, commission of crime, while the service of unexpired sentence is suspended by reason of parole or conditional pardon falls within the contemplation of Article 160 because the crime is deemed committed before the service of sentence. People versus Baliktar. If the pardon is absolute, the criminal liability is extinguished, and thus the penalty is considered as served out. One who committed a crime after the grant of absolute pardon is not a quasi-recidivist, but reiteration may be appreciated. While serving sentence, there is quasi-recidivism where 1. The convicted prisoner killed the victim inside New Bilibid prison. People versus Alvis. Number 2. Where the convicted prisoner escaped from a penal colony and then committed robbery with homicide. People versus Britannia. Habitual delinquency. Habitual delinquent is a person who, within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification, is found guilty of any of the said crimes a third time or of oftener. Article 62 of the Revised Penal Code. The law imposes an additional penalty based on the criminal propensity of the accused apart from that provided by law. For the last crime for which he is found guilty, habitual delinquency is not, however, a crime in itself. It is only a factor in determining the total penalty. In fact, the provision on habitual delinquency is found in Article 62 of the Revised Penal Code on application of penalties and not in Book 2 thereof, which defines felonies. Almeida versus Villaluz. Serious and less serious physical injuries. According to Justice Regalado, the term serious or less serious physical injuries in Article 62 should be understood to have been used in the technical term. Thus, frustrated homicide, or slight physical injuries is not within the contemplation of the word serious or less serious physical injuries. Robbery. The robbery for purposes of habitual delinquency may include robbery with homicide or robbery with serious physical injuries. In case of robbery with serious physical injuries, conviction thereof shall be considered as one. Special complex crime consisting of 2 felonies is technically one crime. Stages. Habitual delinquency is applicable to the crimes mentioned in the law, regardless of the stage of execution. Offender who commits a crime, whether attempted or frustrated, subjectively reveals the same degree of depravity and perversity as one who commits a consummated crime. To exclude him from the operation of rule on habitual delinquency would thwart its purpose and expose society to a constant menace from such delinquent who, when he resolves to commit a crime, certainly does not propose not to go beyond an attempt or a frustration, but rather to consummate it. People versus Abuyan. Accomplice and accessories. Habitual delinquency applies to accomplices and accessories of habitual delinquency crimes. The participation of offenders in committing those crimes repeatedly, whether as principals, accomplices, or accessories, reveals the persistence in them of the inclination to wrongdoing and of the perversity of character that had led them to commit the previous crimes. Recidivism and habitual delinquency. One who is convicted of robbery with homicide and was previously convicted for theft 3 times is a recidivist and habitual delinquent at the same time. These habitual delinquency crimes are embraced in the same title of the Revised Penal Code on crimes against property. Both circumstances of recidivism and habitual delinquency shall be appreciated against him, since the effects thereof are not inconsistent with each other. The effect of recidivism is the application of the penalty for theft in its maximum period, while the effect of habitual delinquency is the imposition of a penalty in addition to the principal penalty for theft. However, while recidivism will aggravate the principal penalty for theft, it cannot aggravate the additional penalty for habitual delinquency because recidivism is inherent in habitual delinquency. People versus Tolentino. A convict can be a habitual delinquent without being a recidivist. Not all habitual delinquency crimes are embraced in the same title of the revised penal code, such as theft, falsification, and serious physical injuries. If the habitual delinquency crimes are not embraced within the same title, the convict is a habitual delinquent but not a recidivist. On the other hand, a convict can be a recidivist without being a habitual delinquent. One who is convicted of theft, estafa, and robbery is a recidivist because these crimes are embraced in the title of the revised penal code on crimes against property. However, he is not a habitual delinquent if the interval of time between his last release or conviction and present conviction is more than 10 years. One who is convicted of acts of lasciviousness, seduction, and abduction is a recidivist because these crimes are embraced in the title of the revised penal code and crimes against chastity, but he is not a habitual delinquent since they are not habitual delinquency crimes. Continued crime. In order that continued crime or delito continuado may exist, there should be 1. Plurality of acts performed separately during a period of time. 2. Unity of criminal intent and purpose. And 3. Unity of penal provisions infringed upon or violated. Santiago versus Garchitorena. Single larceny rule. Under the single larceny doctrine, that is, the taking of several things, whether belonging to the same or different owners, at the same time and place constitutes but one larceny or theft. Single larceny rule is species of delito continuado, which is specifically applicable to theft. In People versus Tumlos, the theft of the 13 cows owned by 6 owners involved 13 acts of taking. However, the acts of taking took place at the same time and at the same place. Consequently, accused performed but one act. The intention was likewise one, that is to take for the purpose of appropriating or selling the 13 cows which he found grazing in the same place. The fact that 8 of said cows pertained to one owner and 5 to another does not make him criminally liable for as many crimes as there are owners, for the reason that in such case neither the intention nor the criminal act is susceptible of division. People versus Jaranilla. Single larceny rule or delito continuado principle is not applicable to violence against women under RA 9262 or sexual abuse under RA 7610. Each incident of sexual intercourse and lascivious acts with the same child exploited in prostitution or subjected to other sexual abuse is a separate and distinct offense under Section 5, letter B of RA 7610. The offense is similar to rape or act of lasciviousness under the revised penal code, in which each act of rape or lascivious conduct committed against the same victim should be the subject of separate information. People versus Lavides. Psychological violence committed by the husband against his wife on 2 different occasions constitutes 2 counts of violence against women under RA number 9262. Dinamling versus People. Single criminal impulse to commit robbery. Several acts, which are performed separately during a period of time under a single criminal intent in violation of penal provision, constitute a continued crime. Thus, several acts of taking away by force the money and valuables of the employees working in Energex gasoline station committed under a single criminal intent to commit robbery in that place in violation of a single penal provision constitute a continued crime of robbery. Single criminal impulse to satisfy lust, where the penis of the accused was inserted into and withdrawn from victim's vagina 3 times for purpose of changing position. People versus Iran, or 2 times for purpose of resting for 5 to 10 seconds. The several penetrations motivated by a single criminal intent to satisfy his lust in violation of single penal provision constitute a continued crime of rape, but where the penis of the accused was inserted into and withdrawn from victim's vagina 3 times for the purpose of resting for 5 minutes, he satisfied his lust every time he would withdraw his penis to rest. Since the 3 penetrations were motivated by separate 3 criminal impulses to satisfy his lust, the delito continuo principle is not applicable, and hence he is liable for 3 separate crimes of rape. People versus Lucena. different criminal impulses to defraud a single victim on different occasions. There is no unity of criminal intent or purpose because while both offenses committed by a consisted of conversion of sums of money belonging to the offended party, they took place on different dates and under different circumstances. Thus, each day of conversions constitute a single act with an independent existence and criminal intent of its own. All the conversions are not the product of a consolidated or united criminal resolution because each conversion is a complete act by itself. Hence, this is not a continuous crime of estafa through misappropriation. People versus Ledesma. Different criminal impulses to defraud different victims. The syndicated estafa charge in one case is different from the syndicated estafa charge in the other cases. While these cases arose out of the same scheme, the fraudulent acts charged were committed against different persons, hence, they do not constitute the same offense. People versus Balasa. This is not delito continuado since the accused have criminal intents to defraud as many as there are victims defrauded. The series of acts committed against the 7 lot buyers was not the product of a single criminal intent. The misrepresentation or deceit was employed against each lot buyer on different dates and in separate places. Hence, they originated from separate criminal intents and consequently resulted in separate felonies. Moreover, after the commission of one estafa, the accused could not have had the foreknowledge as to when or whether they could replicate the same felony against another victim still necessarily unknown. Ilagan versus Honorable Court of Appeals. Foreknowledge principle. In Gamboa versus Court of Appeals, L41054, accused cannot be held to have entertained continuously the same criminal intent in making the first obstruction on October 2, 1972 for the subsequent obstructions on the following days and months until December 30, 1972, for the simple reason that he was not possessed of any foreknowledge of any deposit by any customer on any day or occasion, and which would pass on to his possession and control. At most, his intent to misappropriate may arise only when he comes in possession of the deposits on each business day, but not in the future. Since petitioner company operates only on a day-to-day transaction, as a result, there could be as many acts of misappropriation as there are times the private respondent obstructed and or diverted the deposits to his own personal use and benefit. People versus Dichupa. If the accused committed the first criminal act without foreknowledge that he will commit the second, the acts are not constitutive of a continued crime, since the criminal acts could not be said to have been committed under a single criminal intent or impulse. Exas Punog Barangay was angered when he discovered a tap from the main line of the public water tank. On separate occasions, he threatened to kill and crack the skulls of 3 suspects, A, B, and C. There is no continued crime of grave threat, since the 3 crimes were not committed under a single criminal impulse. X has no foreknowledge that he will chance upon the second and third victims at the time he was committing the first threat. Several threats can only be considered as continued crime if the offender threatened 3 individuals at the same place and at the same time. Malum prohibitum. The basis of delito continuado principle is the singularity of the criminal intent or impulse. Hence, this rule does not apply in malum prohibitum because malice or criminal intent is immaterial. Violation of BP 22 is malum prohibitum. Thus, the drawer, for issuing several bouncing checks, is liable for violations of BB 22 as many as there are checks issued. Lim versus People. Corruption under Section 3, letter E, RA number 3019, partakes the nature of malum prohibitum. However, this crime must be committed with criminal intent, since evident bad faith or manifest partiality is an element thereof. Since criminal intent is material in this crime, the doctrine of delito continuado, which is based on singularity of the criminal intention, is applicable. In Santiago versus Gerti Chorena, the several acts of the accused of favoring 32 aliens on the same period of time in violation of the anti-graft law were considered as constitutive of one continued crime. Continuing crime, delito continuado, continuous or continued crime, and continuing crime are distinguished as follows. 1. Delito continuado is a single crime produced by several acts performed separately during a period of time under a single criminal intent in violation of a single penal provision. Continuing crime is one which is consummated in one place by reason of the nature of the offense. The violation of the law is deemed continuing. 2. The purpose of the delito continuado principle is to treat several criminal acts committed under a single criminal impulse in violation of a single penal provision as one crime. The purpose of the principle is continuing crime is to determine the proper venue, validity of arrest, and the commencement of the running of prescription. Kidnapping with homicide is a continuing crime if the victim was kidnapped in Manila and murdered in Batangas. The regional trial courts of Manila and Batangas shall have jurisdiction to try the kidnappers. If the crime is continuing, the term of prescription commences to run from the date the crime ended. Arches versus Bellosillo. Rebellion is a continuing crime. Accordingly, a rebel may be arrested at any time, with or without warrant, as he is deemed to be in the act of committing the offense at any time of the day or night. Special complex crime and complex crime. Special complex crime. A special complex crime or composite crime is composed of two or more crimes for which the law fixes one specific penalty. It is also called special indivisible crime. The term indivisible means that components of the special indivisible crime could not be divided and treated as separate. Original design. In special complex crime, the original design of the offender is to commit the principal component thereof, and there must be a direct connection or intimate relationship between the components thereof. For example, in special complex crime of rape with homicide, the original design of the offender is to commit rape, and there must be a direct connection, an intimate relationship between rape and homicide. People versus Villaflores. Identification of the original design of the accused is very important to determine the crime committed. Original design is to kill. If the original design is to kill the victim, there is motive to kill. An accused killed the victim and took his property as an afterthought. The crimes committed are homicide or murder and theft, or homicide and robbery by using force upon the thing. Original design is to rob. If the original design is to rob the victim, example, there is no motive to kill, and the accused killed the victim and took his property, or vice versa, the crime committed is special complex crime of robbery with homicide. People versus Ladiana. In robbery with homicide, robbery is the central purpose and objective of the malefactor, and the killing is merely incidental to the robbery. The intent to rob must precede the taking of human life, but the killing may occur before, during, or after the robbery. People versus Ladiana. Homicide is a component of robbery with homicide if it is committed to facilitate the robbery or the escape of the culprit. B. To preserve the possession by the culprit of the loot. C. To prevent discovery of the commission of the robbery. Or D. To eliminate witnesses to the commission of the crime. People versus Orozco. However, the law does not require that the sole motive of the malefactor is robbery. Even if the malefactor intends to kill and rob another, or the intent to rob was tempered with a desire also to take revenge, it does not preclude his conviction for the special complex crime of robbery with homicide. People versus Daniela. If the original design is to rob the victim, and the accused took the property of the victim and then raped her, or vice versa, the crime committed is robbery with rape. People versus Canastra. If the original design is to rob the victim, and the accused took the property of the victim, and then raped her and killed her, or killed a second victim, the crime committed is special complex crime of robbery with homicide and rape. People versus Lascuna. Rape is not an aggravating circumstance, but just a component of this special complex crime. Original design is to rape. If the original design is to rape the victim, example, rape is committed first, and the accused raped victim and took her property as an afterthought, the crime committed is rape and theft. If the original design is to rape the victim, and the accused entered the house of the victim with the use of picklock, raped her, and then killed her, and took her property as an afterthought, the crimes committed by the accused are a special complex crime of rape with homicide and separate crimes of theft. However, illegal possession of picklock shall be considered as a component of rape with homicide. 2009. Even though the original plan is to rob, rape, and kill the victim, if at the time of the execution of the crime their intent to rape overshadowed their intention to rob her, the crime committed is not robbery with homicide and rape. They are liable for rape with homicide and theft. At the time of execution, the accused did not take any interest on victim's belongings, notwithstanding her pleas for the accused to take them in exchange for her life. They persisted in satisfying their lust and even helped each other in their bestial acts. If not for the accidental touching of victim's ring, the accused's intent to rob would have been totally forgotten, as the culprits had dumped her body to hide their crime from immediate discovery. People versus Flores. Rape with homicide. Rape with homicide is a special complex crime under Article 294 of the Revised Penal Code, and not a complex crime under Article 48. Raping a dying victim. Stabbing the victim and raping her while she was dying is not a special complex crime of rape with homicide, because the original design of the victim is to kill and not to rape the victim. These are not separate crimes of murder and rape, since the bestiality at the threshold of death of the victim shall be regarded either as a form of ignominy, causing disgrace, or as a form of cruelty which aggravated the murder because it was unnecessary to the commission thereof. Homicide. In the special complex crime of rape with homicide, the term homicide is to be understood in its generic sense and includes murder and slight physical injuries committed by reason or on occasion of the rape. Hence, even if the circumstances of treachery, abuse of superior strength, and evident premeditation are alleged in the information and are duly established by the prosecution, the same would not qualify the killing to murder, and the crime committed is still rape with homicide. However, these circumstances shall be regarded as ordinary aggravating. People versus Laog. By reason or on the occasion of rape. The phrase by reason of the rape obviously conveys the notion that the killing is due to the rape, which is the crime which the offender originally designed to commit. The victim of the rape is also the victim of the killing. The indivisibility of homicide and rape, attempted or consummated, is clear and admits of no doubt. On the other hand, the phrase on the occasion of the rape, as shown by Senate deliberations, refer to a killing that occurs immediately before or after, or during the commission itself of the attempted or consummated rape, where the victim of the homicide may be a person other than the rape victim herself for as long as the killing is linked to the rape, became evident. People versus Villaflores. A and B were walking along the rice paddies when X suddenly assaulted them with a lead pipe. X killed A and thereafter raped B. X is liable for a special complex crime of rape with homicide. There is no doubt that X killed A to prevent her from aiding B or calling for help once she is able to run away, and also to silence her completely so she may not witness the rape of B, which is the original intent of X. People versus Laog. If the accused infected the victim with gonorrhea in the course of rape, and as a consequence the latter died, the crime committed is special complex crime of rape with homicide. If the victim did not die, the crime committed is qualified rape. Infection of sexually transmissible disease is a qualifying circumstance. Rape and attempted or frustrated homicide. If by reason or on occasion of rape or attempted rape, homicide is committed, this is a special complex crime. If by reason or on occasion of rape, attempted or frustrated homicide is committed, this is not a special complex crime. The accused is liable for separate crimes of rape and attempted or frustrated homicide. In People versus Isla, with respect to the stabbings, it appears that Isla committed two acts. The first was while he was ravishing AAA. The court considered this and the rape as one continuous act, the stabbing being necessary, as far as he was concerned, for the successful perpetration of the crime. When Isla testified, he claimed that he had to use the knife as so he could have sexual intercourse with her. The second stabbing took place after consummation of the rape act. According to AAA, after her defilement, she noticed the knife bloodied and she tried to wrest it from him. In their struggle, she was stopped under her lower left breast, but she was able to force Isla to drop the knife. This second stabbing is a separate and distinct offense, frustrated homicide, as it was not a necessary means to commit the rape. It was intended to do away with her life. Suicide. Ordinarily, homicide means killing another person. Therefore, the person responsible for the death of the victim must be the offender. But in the case of People versus ARPA, the victim herself, who jumped from boat, is responsible for his own death, and yet the Supreme Court convicted the accused of robbery with homicide. In other words, death caused by the victim himself is considered as homicide, which is a component of robbery with homicide. Hence, it is submitted that suicide or death caused by the victim himself can be considered as homicide as a component of special complex crime of rape with homicide. 2014. Robbery with homicide. Once a homicide results by reason of, or on the occasion of the robbery, the felony committed is robbery with homicide. Resulting death. A robber, in order to scare the occupants of a house, fired one shot at the ceiling without any idea that somebody was hiding therein. The victim hiding in the ceiling was accidentally hit by the bullet and died as a result thereof. The robber should be held liable for robbery with homicide, despite the fact that the killing was accidental. Under the English version of Article 294, there is special complex crime of robbery with homicide when homicide is committed by reason or on the occasion of the robbery. However, Spanish text of the provision uses the phrase resultare homicidio. Thus, there is special complex crime of robbery with homicide when homicide results by reason or on the occasion of the robbery. In robbery with homicide, it is immaterial that the death would supervene by mere accident provided that the homicide resulted by reason or on the occasion of the robbery. People versus Mangulabnan. After committing robbery by means of violence and intimidation, the robbers rushed into the car, and one of them pulled the car out of the curb, hitting and killing a pedestrian. The crime committed is special complex crime of robbery with homicide, even though the death of the victim is accidental. A robber in the course of robbery brought out his gun, but he accidentally pulled its trigger. The bullet went through the window, hitting a neighbor that killed him. The crime committed is robbery with homicide. 2013. Time of killing. A conviction of robbery with homicide requires that the robbery is the main purpose and the killing is merely incidental to the robbery. The intent to rob must precede the taking of human life, but the killing may occur before, during, or after the robbery. People versus Hinlo. Victim of homicide. The robbery with homicide. It is immaterial that the victim of homicide is a third person, that the victim of homicide is one of the robbers, that two or more persons are killed. However, if there are two persons kidnapped and killed, the accused is liable for 2 counts of kidnapping with homicide, that the victim was killed by a stray bullet which came from a police officer, that one of the robbers was killed by a police officer or by a co-robber. Homicide. The word homicide is used in its generic sense. Homicide thus includes murder, parricide, and infanticide. It is only the result obtained, without reference or distinction as to the circumstances, causes, or modes, or persons intervening in the commission of the crime, that has to be taken into consideration. There is no such felony of robbery with homicide through reckless imprudence or simple negligence. The constitutive elements of the crime. namely robbery and homicide, must be consummated. Treachery shall be appreciated in robbery with homicide, although said crime is classified as a crime against property and a single and indivisible crime. However, like abuse of superior strength, treachery is only a generic aggravating circumstance and does not qualify the killing to murder, which will be used as a component of this special complex crime. There is no special complex crime of robbery with murder under the revised penal code. Therefore, the accused will be held liable for robbery with homicide aggravated by the circumstance of treachery, and not robbery with murder qualified by the circumstance of treachery. However, in kidnapping with homicide, the Supreme Court is sometimes describing it as kidnapping with murder or kidnapping for ransom with murder. Thus, killing the kidnapped victim by means of fire constitutes special complex crime of kidnapping with murder. Moreover, murder can be integrated with piracy, highway robbery, brigandage, or hijacking to form a special complex crime of piracy with murder, qualified piracy, highway robbery, brigandage with murder, or hijacking with murder. Thus, treachery can be appreciated as a qualifying circumstance in these crimes. Other crimes. In robbery with homicide, it is immaterial that aside from the homicide, other crimes such as rape, intentional mutilation, or usurpation of authority is committed by reason or on the occasion of the crime. In this special complex crime, all the felonies committed by reason of or on the occasion of the robbery are integrated into one and indivisible felony of robbery with homicide. People versus De Leon. Direct assault with attempted homicide, or multiple rapes or acts of lasciviousness committed by reason or on occasion of robbery shall be considered to be integrated into the special complex crime of robbery with homicide under the De Leon principle. Acts of homicide, physical injuries, and other offenses committed by reason or on the occasion of robbery are components of robbery with homicide. This De Leon principle can be applied by analogy to rape with homicide and kidnapping with homicide. In rape with homicide, illegal possession of picklock committed on occasion or by reason of rape shall be integrated into special complex crime of rape with homicide. In kidnapping with murder by means of fire, rape committed in the course of detention shall be integrated into the special complex crime of kidnapping with murder. Ordinarily, other crime committed in the course of robbery with homicide will not be treated as a separate crime. However, if the building is burned to conceal the crime of robbery with homicide, arson will be considered as a separate crime. Under Article 320 of the Revised Penal Code, burning a building for the purpose of concealing or destroying evidence of another violation of law is destructive arson. Other crime committed in the course of special complex crime will not be treated as a separate crime unless it is not connected with it. Hence, illegal possession of dangerous drugs cannot be considered as a component of robbery with homicide. Theft committed after raping and killing the victim as an afterthought cannot be considered as a component of rape with homicide. Direct connection. In People versus Barut, after taking property in the house of the victim by means of violence and intimidation, a fight between the robbers and the neighbors of the robbery victim ensued. The killing of one of the members of the rescue party resulted from that fight. Hence, it was connected with the robbery, although the killing of the victim was perpetrated after the consummation of the robbery and after the robbers had left the victim's house. The homicide is still integrated with the robbery or is regarded as having been committed by reason or on the occasion thereof. In People versus Kim McGinn, after taking the passenger's personal belongings, accused alighted from the jeepney. At that moment, robbery was consummated. Some of the passengers, however, decided to report the incident to the proper authorities. Hence, they went to their nearest police station. There, they narrated what happened. The police eventually decided to go back to the place where the robbery took place. Then they saw the suspect on board a pedicab. 3 suspects were caught and left under the care of Swing, a police officer. It was then that Swing was killed. Clearly, the killing was distinct from the robbery. There may be a connection between the two crimes, but surely there was no direct connection. In Barut case, the fight between the robbers and the rescue team resulting in the death of the victim is just inseparable part of the event involving robbery. Hence, the connection between the robbery and the homicide is direct. On the other hand, in Kemmigan case, there is an appreciable interval of time between the robbery and the pursuit of the robbers causing the fatality. Hence, the connection between the robbery and homicide is not direct. Where long after the robbery, one of the robbers realized that they had left the door of the building open, and the robbery would be easily discovered, whereupon he returned to close that door, but he had to kill the janitor who also arrived at the scene. It was held that the killing was separate crime, as it was only indirectly connected with robbery. Robbery by means of violence or intimidation with homicide. Robbery with homicide is a special complex crime found in Article 294 of the Revised Penal Code, which governs robbery by means of violence or intimidation. Hence, to be held liable for robbery with homicide under Article 294, it is important that there is a connection between robbery by means of violence or intimidation and homicide. Theft with homicide. If by reason or on occasion of theft, homicide has resulted, this is not a special complex crime of robbery with homicide. Theft is defined under Article 308 of the Revised Penal Code. There is no special complex crime of theft with homicide under this provision. In People v. Concepcion, the accused snatched the victim's shoulder bag, which was hanging on her left shoulder. No violence, intimidation, or force was used in snatching her shoulder bag. Given the facts, the snatching of the shoulder bag constitutes the crime of theft, not robbery. The co-conspirator of the accused, who was driving the motorcycle, died because he lost control of the motorcycle and crashed in front of a taxi. Since the accused as passenger in the motorcycle did not perform or execute any act that caused the death of his companion, he cannot be held liable for homicide. In People v. Jaranilla, accused took roosters without violence or intimidation. By reason thereof, the police authorities chased them. One of the accused shot the policeman. The trial court convicted the accused of robbery with homicide under Article 294. However, the Supreme Court convicted them of theft and direct assault with homicide. According to the court, there is no evidence that in taking the roosters from their coop, violence against or intimidation of persons was employed. Hence, Article 294 on robbery with homicide cannot be invoked. Accused without unlawful entry or forcible entry committed theft inside a building. After driving for about 1 kilometer, he returned to the building because he left his wallet with his ID. He was surprised to find a person holding his wallet. Accused killed the victim. He is liable for separate crimes of theft and homicide. The unlawful taking without violence, intimidation, or force upon things constitute theft. Even if there is a connection between theft and homicide, he is not liable for a special complex crime because there is no such crime of theft with homicide in the Book of Statutes. Moreover, since the unlawful taking is already completed when the killing was committed, the connection between the two is not direct. Robbery by using force upon thing with homicide. If by reason or on occasion of robbery by using force upon thing, homicide has resulted, this is not a complex crime of robbery with homicide. Robbery by using force upon thing is found in Articles 299 and 302 of the Revised Penal Code. There is no robbery by using force upon thing with homicide under these provisions.